the HC syllabus for working in the ICT industry. And section 2 is really all about employment. I'm going to cover the different types of employment you can have: full-time, part-time, casual, contract, etc. The different ways you can be employed, awards, agreements, and the rights and responsibilities that you have as an employee to the company that you work for. So where does this link in? Like I said, HC outcomes, we're in the working in ICT unit, and we're looking at heading number 2, employment. There's a whole heap of stuff we've got to cover here. We've got to get started with this concept that there are a couple of different ways that you can be employed. The main type of employment is permanent employment. This is, when I say the main type of employment, this is what most people are working towards, permanent employment, because there's a whole heap of job security. A lot of people, including yourselves at the age of 15, 16, 17, 18 years old while you're at school, may have a casual job. And so you might find yourself sitting in that middle bucket. And then there are also fixed term employment types. This is for people that are employed only for a specific time or for a specific task to be completed. So let's get started. We'll work on just the permanent employment type to begin with. Permanent employment could be full-time or part-time. You are engaged to do work each week. Every week you're expected to come to work and do the hours that your boss has put you on the roster for. And it's usually a set number of hours each week. Full-time, for example, is guaranteed 38 hours of ordinary hour work per week. Now what that means, if your job is 9 to 5, then you'll be working 9 to 5, 5 days a week. That gets you up to your 38 hours. For me as a teacher, for example, I am permanent. I have a job all the time. I am full-time. I work here 5 days a week, and I get around about 38 hours of work per week on my roster. I agree to the hours when I start working there. Now, when I worked at the cinemas, for example, putting my previous life's hat on, and I worked at the cinemas, it started as a casual job, but when it became a permanent job, I agreed to the hours that I would have to work. And in that capacity, sometimes I had to work nights, sometimes I had to work weekends, sometimes I had to work on public holidays, because they were the hours I had agreed to as part of my permanent job. In teaching, I don't have to work nights and weekends usually, but sometimes I do. Parent-teacher nights, for example, and open days on the weekends. Now, I agree to those hours when I take on the employment. One of the other benefits of having this permanent full-time employment with my boss is that I'm entitled to leave. Leave is where you get paid when you're not at work. For example, if I am sick, one of the days that I call in sick at work and I'm not able to come in, I get paid for that day, but I don't have to come to work. So that's one of the big benefits of being a permanent employee, is that you get access to this leave. I also get annual leave. Annual leave is where you're able to take holidays. So you might work for a whole year, and at the end of the year you've saved up all your annual leave, and you might have 2 weeks that you can use to go on a holiday. You go on that holiday and you still get paid. You get paid your normal full-time wage, but you don't have to go to work. How good's that? So that's leave. As a permanent employee, I am also entitled to access all of the rules and provisions that exist around unfair dismissal. For example, if my boss fires me, if I think it's unfair, then I have access to all of the resources of Fair Work Australia to question whether it was fair, and if it wasn't fair, to get my job back. Okay, so I have access to those unfair dismissal provisions. So that's full-time work. Remember, full-time, permanent, and working 38 hours per week. If I'm a part-time employee, I have all of the same benefits. The only difference is I work less than 38 hours per week. I still agree to how many hours I'm going to work, and it's still guaranteed work, but the difference is I don't have to do 38 hours. So I might do 8 hours per week, or I might do 15 hours per week, or I might do 25 hours per week. Okay? And me and the company that I work for agree to those hours when I start working there, and they pay me consistently those hours on a week-by-week basis. That's permanent employment. In the middle then is casual employment. A casual employee is someone that every time they work a shift, they start a new contract with the company that they work for. For example, if I worked at McDonald's right now and I'm a casual employee and I started work this afternoon at 3 o'clock and I finish at 5 o'clock, at the end of that shift at 5 o'clock, technically speaking, I don't work for McDonald's anymore. And then if I get another shift tomorrow that starts at 9 a.m., at 9 a.m. I start working for McDonald's again, and when my shift finishes at 5 p.m., I no longer work for McDonald's anymore. So we call this engaged by the hour. Every single time I'm asked to work by that company, they effectively start a new contract with me, but there's no record, there is a record. There's no accounting for the fact of how long I've worked for that company. You don't add up all of the years that you've worked there if you're casual usually, because there's no thing called continuity of service. They don't add up all of the years that you work there. Okay? Casual employees work irregular hours. You don't have the same shifts every week. You usually get a different number of hours each week. So you might have 3 hours this week, you might have 10 hours next week, and then maybe sometimes you get 30 hours the next week and then back to 3 hours. And some weeks you might not get any weeks anymore, any work at all. Okay? So it's irregular. You're not locked into consistent shifts. You also don't have to work. So as a casual employee, your boss can call you or send you a text message and say, hey, I've got a shift available today. Are you free to work? You don't have to say yes. You're allowed to say no to that. And technically speaking, you shouldn't be able to lose your job because technically speaking, you don't have a job with them unless you say yes. The other thing with casual employment is your company doesn't have to give you any work. So if they are quiet and they're not making much money, particularly now while we're all in lockdown, it's very possible that they don't need you to work this week, so they might not give you a shift. Now, because this type of employment is a very sporadic and very inconsistent, you get this thing called casual loading. It means when you're paid, they pay you just a little bit extra per hour, more than what they pay their full-timer, okay, more than what they pay their part-time employees. They pay you a little bit extra per hour, and it's this thing called casual loading. It's this way of saying, thanks, we understand that you have this really inconsistent career with us, so we pay you that little bit of extra money to compensate you. You're also not entitled to leave. So you might recall when I was talking about permanent employment, I get to take days off work and still get paid, and I don't have to go to work. How good's that? When I'm casual, if I can't do my shift, I don't get paid. Okay? I don't get paid to go on holidays. I don't get paid unless I am actually at work as a casual staff member. The only time you can take time off as a casual staff member is for very rare occasions like perhaps compassionate leave. So maybe you've had a death in the family and you need to attend a funeral. In those circumstances, you can call your boss and explain what's happened, and you no longer would have to do your shift and you can't get fired for that. Okay? You still can be called back in for additional shifts. Okay? But other than that, there's really no way for you to get out of doing a shift as a casual employee once you've said yes to it. Now, there are some occasions for some companies where we have this thing called regular casuals. Now, in my previous life when I used to work at the cinemas, you would recall that I said I was employed as a casual initially. I was what's called a regular casual. I worked the same shifts every single week for a very long period of time. So I became a regular casual. This meant, after many years of doing that I was actually entitled to some of the paid leave. I was entitled to paid sick leave, paid annual leave, because of how long I had been doing these regular shifts. And the reason that exists is because it's the government enforcing that, well, if I was getting the same shifts every week, then my company should have been giving me permanent, either full-time or part-time work. Why did I have to be casual? Okay, so if you are doing the same shifts on a regular basis, you become a regular casual, and in some circumstances, particularly over long periods of time, you actually get some of the entitlements of a full-time and part-time employee, which is a way of companies being encouraged to make you permanent. Now, if I am one of those regular casuals where I work regular basis, I do have access to all those unfair dismissal provisions if I think I've been fired unfairly from my job. But if I only do a couple of shifts here and there and it's not regular, then I'm a casual employee, and the minute they decide they don't want me to work there anymore, they no longer have to give me any shifts because, like I said at the very beginning, every single shift I work is a new contract with that company for that single shift. And at the end of that shift, technically speaking, I don't work for that company anymore. Then we have on the right-hand side fixed term. More often you're going to hear this called contract employment. This is where we hire someone and we ask them to work for a specific period of time. Maybe they're going to work for a 12-month period for us. Or maybe they'll work for a 3-month period for us. Or maybe you hear this in America a lot, they're going to work during the summer for us. So we hire them for the season. Okay? These are fixed term employment types. You can be employed for a period of time, or you can be employed for a task. So for example, you might be hired until the end of a project. So you might be hired until all computers have been updated to Windows 10, and then you're no longer employed with the company anymore. So they'll continue to pay you until that job is done, and then at the end of that time, your job no longer exists. Time or task. Now, the benefit of being in fixed term is you know how long you have secure work for. You know exactly what your benefits are. And you also know that at the end of the contract, you don't have to work for that company anymore. In fact, you don't work for that company anymore. The minute your contract expires, you no longer work for that company. You still get annual leave and personal leave and all those leave entitlements based on the number of hours you've been working, okay, just like a part-time employee would. But you can't, at the end of your contract, say, oh, I was unfairly dismissed. If your contract's ended, you signed it, you agreed to it, you knew that your employment would end there. Okay? You can be employed in a contract, a fixed-term contract, either part-time or full-time. Okay? So we've got 3 main types of employments. For all of those types of employment, full-time, part-time, casual, or contract, there are then 3 main documents that are used to work out how much you get paid and what your employment conditions should be. Now, your pay rate is how much you get paid per hour, okay, or how much you get paid per week, your weekly wage. And then the other term you might hear me saying here is conditions of employment. Conditions of employment are the sorts of jobs you should be expected to do, the sorts of hours you should be expected to work, and all of those sorts of bits and pieces about how you do your job, okay, and all of the benefits that you get associated with your job. Okay? Think of it like a bit of a hierarchy structure. Okay? At the very bottom of the pyramid, we have awards. Awards are the base, the cornerstone, the foundation of employment in Australia. There is nothing below award. The award is the minimum amount of money and the minimum conditions of employment that you can get as an employee in your industry. What that means is there is an award, okay, an award for each industry. Now, I'm not saying award as in like there's a certificate or a trophy. An award is a document. Okay? It's a legal document that explains in very clear detail exactly how much you get paid, how many hours of leave you're entitled to, what days of the week and what hours you should be working ordinarily, when you're entitled to double time, when you're entitled to time and a half. Okay, it's very clearly set out. And these awards are those minimum conditions that exist. There is nothing below the award. Now, where this applies, you might work for a company and you don't know how much you're going to be paid before you start working. You can look up what industry you work in on this site here. So if you click on this link, it's going to take you across to a site where they have all of the awards in Australia, and you can specifically look at each industry, okay, and exactly what you should be paid as a minimum. Okay? Now, we now call awards modern awards. Now, the reason we call them modern awards is because they were actually changed in 2010. There was a major change to the way people were employed in Australia in 2010 where modern awards came out. Before this, it was really a bit of a shambles. Every company was sort of doing their own thing and every industry was doing their own thing, and there was no one really checking it, and it was all out of date. So they went through in 2010 and started the process of upgrading all the awards, okay? Those basic minimum pay rates and minimum conditions of employment. So we've got awards sitting at the bottom of the pyramid. Building up, next layer of the pyramid then, are agreements. Agreements are these additional documents, okay? That's a document, legally binding document, that sits above the award. This is where you agree to pay your employees more than the minimum, okay? Agreements, they tell you the minimum amount that you're entitled to as an employee. Not all companies, not all jobs have agreements, only some do. But this is where your company and the people that work there, the employees, have come together and agreed on some differences to the award. For example, more. Getting better benefits. Paying employees more than you need to. Giving them more leave than you need to. Giving them better working conditions than you need to. You're probably thinking to yourself, why, oh why, would companies agree to give their employees more than they have to? Well, it's pretty simple. Imagine if you worked at Apple and you were hiring your employees and you were giving them the minimum, you were giving them awards, and you might have been paying them $20 per hour. What if a company came in, like Microsoft, for example, and offered your employees $25 an hour to go and work for them? A lot of them would probably leave your company to go work for this company that pays them more. So the benefit of having an agreement between employees and the company is that companies can actually encourage people to work for them by paying them more. We call these employers of choice. Okay? Now, if I have the option of picking which company I was going to work for, I would guess that working for Microsoft pays better than working at Joe's IT repair shop. Okay? They've got more money that they make as a company, so they should be able to pay their employees more. But to know for sure, I would check out the awards and the agreements. So awards are the basic, agreements sit above that, and this is where companies are enabled to pay their employees more and give them better working conditions. Sitting then sort of to the side, but potentially above, is then contracts. Contracts are, again, a document, a legally binding document, but instead of being between the workplace and all of the employees that work there, like in an agreement, a contract is between the workplace and one individual employee. This is where, in contracts, you have the ability for one person to be paid more than everyone else in your company. Where you offer them a contract and you can pay them more and give them better benefits than everyone else in the company as a way of encouraging them to stay working for you, or as a way of thanking them for the work that they do. You can have your contract in writing, or you can have it verbally, so spoken, but they are legally binding, and they should be setting out the terms and conditions of your employment and exactly what it is that you need to do in order to get paid. For the agreements and for the contracts, you can never be paid less than in the award. The award always sits as the bare minimum that is available. Okay? Remember that. Awards are at the bottom, agreements build upon it, contracts build upon it again, pointy end of the pyramid because they're for one person. Agreements, middle of the pyramid because they're for multiple people. Awards at the bottom because they are the foundation that both of those are built upon. So we then start talking about, okay, we now know what these documents are. Let's start talking about what are these terms and conditions of employment. What exactly does it mean to have a term and conditions of employment? Well, the first one that you want to know is the Fair Work Information Statement, the FWIS, it sometimes is called. Now, this is a document that comes from an organisation called Fair Work Australia. They're a government body. They are responsible for making sure that everyone gets a fair go at work. And it gives some really clear details about what you need to do in order to make sure you're giving your employees a fair go when they're working for you. We'll get started with this thing called pay. How much do you get paid? Everyone in Australia, right here, every single person in Australia, if you are an adult, so 21 years old, and you are working full-time or part-time, must be paid a minimum of $19.49 per hour. If you are a casual adult, 21 years or older, you must be paid a minimum of $24.36 per hour. If you're a junior, so we're talking someone 15, 16, 17, 18, 19, 20, you're a junior. If you're an apprentice, or if you're an employee with a disability, there are 3 different categories there, you may be paid less, okay, a percentage. For example, someone who is 20 years old might get paid about 90% of this rate. Someone who's 15 years old might get paid only 65% of that rate. Okay? So that's why as a 16-year-old, you might be paid around about $10 per hour, not $20 per hour, like you can see here. Okay, so that's the first thing, pay. Second thing are these NES, the National Employment Standards. It tells you exactly what a casual employee is entitled to and exactly what a full-time and part-time employee is entitled to. You can see that full-time and part-time employees are entitled to everything, all 10 of the National Employment Standards. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Now, there's actually a couple because they've got some subcategories, but all 10 of the National Employment Standards. You can see casual employees, however, are not entitled to all 10. They are entitled to only some. And even though you can see lots of ticks here to say yes, they're entitled to it, a lot of the time here you'll see this word unpaid. They're entitled to the time off work, but they're not going to get paid for it. Whereas full-timers and part-time are entitled to the payoff, the day off, and they also get paid for it. Okay? It's different for each full-time, part-time, and casual. Sorry, full-time and part-time or casual. So just have a look through those. You need to know these employment standards. You need to know that if you work on a public holiday, you should get another day off later as a way of saying thank you, or you get paid double time. You need to know that you're entitled to 4 weeks of annual leave each year if you're a full-time employee. That means if you work for a company for 10 years and you don't take any holidays, that's 40 weeks, nearly a whole year that you get to take off where you get paid to not be at work. You need to know that everyone, full-time and part-time, gets 10 days off per year for sick leave or for carers leave. Now, what is carers leave? Well, when my daughter is sick and can't go to daycare and I need to stay home to look after her, that's carers leave. Because I'm not sick, I'm caring for someone who is sick. Okay? You can see in addition to that, there's also this thing called carers leave. Okay? But that's additional and it's unpaid. Okay? You can only use this one if you don't have any of these left. Because casuals don't get them, that's all they can use. So there's the National Employment Standards, and it goes through in detail all of the different options that are available for you when you work for a company. And most importantly is this who can help section at the bottom, where it says to you, what do you need to do if you think you're being treated unfairly at work? Well, the first thing is, over here, the Fair Work Ombudsman, they can help you work out how much you should get paid, calculate how much money you should get paid on a weekly basis, etc. And they also make sure that companies comply with all of the rules. Over here is the Fair Work Commission, and the Fair Work Commission is basically responsible for looking out for employees who make a complaint. If you think that you've been treated unfairly at work, you would call the Fair Work Commission and get them to investigate. They would listen to what you said, they'd speak to the company that you work for, find out their side of the story, and then they might sit down and have a mediation session with you so that you can clear up any miscommunications. Okay? So that's the National Employment Standards and the Fair Work Information Statement. We need to think what happens if you have terms and conditions. What are the consequences for breaching those terms? Well, if you're an employee and you're expected to go to work, if you're contracted to go to work and you just don't show up, there has to be a consequence for that. You can't just not go to work and not tell anyone why. And the consequence might be that you get a warning from your boss, and your boss might say, look, if you do that again, there's serious consequences. You might even lose your job. There are times when you might immediately lose your job. For example, if you were doing something illegal while working. Now, if I think maybe you've got a part-time job and you're working at a cash register, if you're stealing from that company, if you're taking money out of the cash register, that's a serious breach of the terms and conditions of your job. They could fire you on the spot, send you home, you're paid up until the minute you stopped working, and then you no longer have that job anymore. Okay, so there are different consequences for each different scenario. And your company usually outlines this information in what's called a code of conduct. And we'll learn a little bit more about that later. Now, I spoke about awards and agreements in a previous slide. There are 3 different documents that I've linked here for you to have a look at. The first is Professional Employees Award. Now remember, the award is the basic. This is where we sit. IT professionals sit in the Professional Employees Award 2010. That's the date it was created. That's what the award's name is. This award document gives us the minimum conditions and minimum pay of our careers, of our profession in IT. These 2 documents here are agreements, not awards, which means they sit higher. This one here is between Apple, the company, and its employees, and this one here is between Telstra, the company, and its employees. When you click on these links, it will open documents as well, and they say the minimum conditions and the minimum pay for that company and their employees. And what you should find is that their conditions and their pay is slightly higher than the minimum set out in the industry award. So moving across, I spoke previously about these consequences, what happens when you breach the terms and conditions. We have codes of conduct. A code of conduct are the rules for your job, okay? What you're expected to do, how you're expected to behave when you are at your job. Now, lots of companies have a code of conduct, okay? The big companies have a code of conduct document that they make you read and sign when you start working for them so that they know you've read it. Some of the smaller companies, it's a little bit more informal and you learn it through the training. For us as IT professionals though, it's very confusing to know how we should behave when we work in lots of different companies. Sometimes we work in manufacturing companies, sometimes we work in education like teachers, sometimes we work in specifically IT companies like Apple or Telstra, okay, or other sorts of companies like that. So the ACS, the Australian Computing Society, have put together a document that outlines how anyone that works in the computing industry in Australia should behave. Now, the Australian Computing Society is an organisation that specifically looks after people that work in IT. They don't look after people that work in factories or on farms. They're only interested in people that work in IT. If you click on this link, it will take you to their code of conduct, where you will see how they expect IT people in Australia to behave. And this is a document, gives you some information about the document. Okay. You scroll down, and there are 6 values that exist in this rule, in this code of conduct. These are the 6 rules that we would expect you to follow as an IT professional. And from now on, we begin to follow as we begin practicing and learning how to be IT professionals. The first thing is that everything we do, it doesn't matter what you want to achieve personally or what your company wants to achieve, you have a responsibility to look after the interests of the public. What that means is your company or you might decide that you want to design a dodgy piece of software or a virus. That's not in the public interest. So you are not to create that virus that is going to be malicious. Okay? You need to make sure that what you do benefits society as number 1. Number 2, make sure you work to your business and personal goals. The second rule there you can see is to enhance the quality of life. What we do, we need to try and make things better for people. Either make things easier, faster, more efficient, in some way make their lives better by the work that we do. Number 3 is honesty, making sure we're being honest in what we do, in the service that we provide, and in the skills that we have. What we mean here is not charging people money for something you haven't done. Okay? Make sure that you're not lying about the things that you've done when you're working for people. Okay? Just generally being honest. The 4th is competency. Okay? This is about making sure that you're working hard, working consistently, diligently, and competently for the people you work for. So if you work for a company, lots of IT people work remotely and no one's really able to see what they're doing. Instead of just sitting there eating cheesels and playing PlayStation when you're meant to be working, you're expected to make sure you are working diligently for your company. They are paying you to work, you should be working. Number 5 is professional development. That means at the end of year 12, okay, when you finish your studies in IDT and you go and get a career in the IT industry, that's not the last bit of study you ever do. The expectation is that you continue learning new things so that you can keep up to date with how things are changing, how IT is developing in the country and in the world. And lastly is that you'll always be professional. So there's some more information that tells you more specific details about each of these different aspects of the code. And that's something that you'll need to come back to when you're working on our Canvas work for this particular task. Okay? We'll go now back to our slides and we'll continue on with this lecture. Moving across, we now have this concept that we're going to look at called equal employment opportunity. This is linked really closely into legislation, and you'll see the legislation shortly. But we basically need to understand one thing. When we work in companies, we don't want to hire 10 of the same people. We don't want everyone to be exactly the same. We want a range of people to work for us. We call this diversity. It might be people from different cultural backgrounds, people from different life experiences, people of different gender, people of different race potentially. All of these differences improve the diversity in the workplace. And when we have a big range or a high diversity in our companies, we actually have access to different perspectives, different levels of experience, and different knowledge that they bring with them from their backgrounds. Okay, whether it be their background in terms of culture, age, previous companies they've worked for, etc. And that's the main thing you need to understand when I start talking about this equal employment opportunity. So here it is. Equal employment opportunity is a law. It's federal law, so it's Australian law. It's not New South Wales law, it's Australian law. It covers all of the states. It was written back in 1987, is the most recent version. And in this law, it says that it is unlawful, so it's against the law, for you to discriminate against people, right, based on a certain number of reasons. And these reasons overlap with another bit of law. This is a New South Wales law called the Anti-Discrimination Act. Now, discrimination is unlawful during the time that you are hiring people, during the time they work for you, and during the time you're ending or terminating their employment. What that means is you can't decide that you're not going to hire someone because of their race. You can't turn around and say, oh no, only Aussies are going to work at this company. We don't want any English people or any Asian people or any New Zealand people. You can't discriminate. That's against the law under these laws. You also can't say, oh, I'm going to give John a promotion because he's a great guy, and Janice, she's a girl, I just don't think it's right. We'll give it to a guy. That would be unlawful under these laws. And also, if times are tough in your company and you need to fire someone and you've got to pick between the people that you work for, you can't say, oh, okay, I'm going to get rid of Brendan because he's the youngest, or I'm going to get rid of Sandra because she's a girl, or I'm going to get rid of Jack because he's Fijian. You can't decide anything about people's employment, hiring, the way they work, their promotions, or firing them based on anything that's covered in these prohibited grounds of discrimination. Now, what do we mean by these prohibited grounds? We mean you can't discriminate based on race, age, gender, sexual orientation, family matters, who they know, who they associate with. There is really nothing that you can discriminate, and nothing you should discriminate against anyone ever. Okay? But these are the two laws, federal law here and state law here, that we need to comply with. Now, we have this thing called reciprocal rights, and it is really tough to remember. But reciprocal rights means that if I am a boss, I cannot fire people, hire people, or promote people for any reason that is about their race, gender, sex, etc. That would be unfair. Now, I have that responsibility to my employees not to do that. They have the right, okay, this reciprocal right, so I have to look after them, but they also have to look after me. It means they can't then turn around and discriminate against other people or discriminate against their boss or anything like that. Both the employee and the employer share the responsibility of preventing discrimination. That's what we mean about reciprocal rights. It's the boss looking after you and you looking after the boss and you being looked after by the boss. Okay? Reciprocal rights. So what then happens if we think we're being discriminated against or we think something's gone wrong? Well, there's usually two different processes that you can follow. The first is what we call internal, that's within your company. Now, within your company, you usually have what's called a grievance procedure. This is a process you follow when you think something is wrong at work. The second thing is that you can report up the chain of command. So if you think that you're being treated unfairly at work or you're being discriminated against at work unfairly, maybe you didn't get a promotion because you think they gave it to someone because of an unfair reason, the first thing you should do is work up the chain of command, which might be to tell your boss. Now, if your boss is the person who you think has discriminated against you, it wouldn't be wise to tell them because they might continue to discriminate against you. So in that case, you might want to go above them and go to the next level up and see their boss. And you continue working up the chain of command until you get a resolution. You don't always jump straight to the CEO to make a complaint. You need to make sure you follow the procedure and work up your chain of command. For example, me here at school, my boss is Mr. Fetterplace. Every time I have a problem, I don't go straight into his office and tell him. I tell my direct manager. Now, for when I'm working in IDT, when I'm working in construction, Mr. Ha is my direct manager. So when I've got a problem, I go and see him. Now, if I think Mr. Ha is the problem, then I go and see his boss, and his boss is Miss Brame. So I go and see Miss Brame, and if she can't help us, then we go to her boss, and her boss then is Mr. Fetterplace. So we work up the chain of command. Now, the other option in bigger companies is if you have a HR department, a human resources department. This department, this group of employees at your company, if you've got one, they're responsible for making sure that people's employment goes well. They usually look after your pay, they usually look after promotions, they usually look after hiring and firing of staff and all of those sorts of things. They're also there if you think there's some sort of discrimination happening. That's part of their job as well, to mediate those sorts of things. Now, if you don't feel comfortable following those procedures in work, or you have followed them and they didn't work, we then, after you've tried the internal processes, would recommend that you work on external processes. And the external process is to go to the Anti-Discrimination Board. Now, this is a group of people, they work for the government. Their job is to listen to your side of the story. Then they contact your boss and listen to his side of the story. And then they sit you down in a meeting, might be over the phone or in a room, where they mediate or conciliate. They have this process where they get everyone to listen to each person's side of the story, because most of the time it's a misunderstanding that has happened and people haven't understood the information, or they've gotten really angry and weren't listening properly and they've missed some key bits of information to explain the process, which might not have been a discrimination at all. If they go through that process and they still don't resolve the issue, the next step then is the New South Wales Civil and Administrative Tribunal. This is basically like going to court, where a group of people then make a judgment on your employment and whether it was unfair or whether it was fair. Okay? That's the end of today's slides. Okay? I know there's quite a lot of information there. Really want you to make sure you go back, you've understood it, you've written your notes, and then to go through the information we've shared with you on Canvas and to answer the questions in the quiz to your best of your ability. Okay? There is a lot of work in our assignment for this unit that comes directly from today's video. So make sure you go back into our assignment to make sure you are up to date with the little bits and pieces of work that you can be chipping away at for your assessment for this unit. Thanks very much.